Hello, and thank you for joining us. This presentation aims to showcase an attack that was conducted against the United States and the challenges that arose from dealing with cyber forensics on a global spectrum. In recent years, there has been an emergence of trends towards new cybersecurity legislation globally. These legislations aim to develop tools to cope with risks of the digital area, and they do so through collaboration between the public and private sectors. Specifically, the goal is to create an exchange of information and creation of national cybersecurity agencies. Though this is the case, there is still a lack of international governance set in place that fosters the collaboration between states when a cyber incident occurs. Before we get into the challenges faced when dealing with intrusions that occur across state lines, it is important to understand what happened during this attack. A user on a trusted network unknowingly opened a malicious phishing attachment that appeared to be a legitimate Excel file. The Excel file secretly generated a ransomware code that encrypted all files until the ransom was paid. The system was also hindered because the attack triggered an ample amount of system memory usage, thus slowing down its functions. After the investigation was brought forth, it was determined that the bad actor that attributed to the cybercrime was known to be Amsterdam in the Netherlands. The United States was able to determine this through an analysis of indicators and anomalous activities. Actors in Amsterdam used social engineering tactics to initiate this cybercrime. It is now time to get into the challenges faced when dealing with cybercrime on a global spectrum. Failures of international law addressing cyber activities come from three problems. For one, there is a lack of definition when it comes to important operational concepts. Though cybersecurity has been a growing issue, states have never agreed to a common definition of what use of force and armed attacks are. In leaving these definitions gray, states are left to interpretive differences that shape their interstate negotiations. Failing to come to a consensus on agreeable definitions means that individual states may determine their own factors regarding severity, immediacy, invasiveness, and identity of attackers when it comes to a cybercrime. The conceptual ambiguity has hindered states from petitioning an international set of standards to recognize cyber attacks within their own values. Consequently, no state outside of the United States of America has recognized cyber attacks as a use of force. Without clear and defined terms, it is unlikely for a state to accuse another of an internationally wrongful act. Another issue stems from the fact that international law is considered extendable to non-state actors, even though it does not address the degree in which non-state actors are diverse. Applying international law to non-state actors involved in cyber business requires clearly defined set of standards for each, yet there is no standard to which states have agreed upon. Lack of conceptual clarity deepens the issue of attribution in cyberspace. Attribution is necessary for international laws to establish facts to execute the rights of affected states, but it does not specify the consequences for violators. There are no set standards that produce sufficient evidence for states under international law. Specifically, international law does not present specific rules on how much and what kind of evidence is needed to make a case of attribution. Because of this, some states are forced to resort to nothing more than making broad statements of necessary condemnation. States have chosen not to subject themselves to international standards. Existing laws do not include abstract policy guidelines, do not extend penalty for violations, nor do they offer incentives for compliance. This means that states receive no legal protection from international organizations from cyber attacks from non-state actors. Though violators would face reputable costs and risk political action from their own states, many of them care more about abusing systems for immediate gains. Continuing on this, lack of international regulation also hinders e-discovery. Global corporations have various offices and thousands of employees scattered around the world, and as a result, e-discovery can be complicated by international laws and regulations regarding discovery around and across national borders, and can also affect the legal discovery within the United States. Even in cases where the United States courts follows the federal rules of civil procedure and have jurisdiction in other countries, there still lie challenges associated with international e-discovery. For one, there is an issue with locating data. Widespread use of cloud computing and online storage hinders the ability to locate enterprise security intelligence. This is due to the fact that electronically transmitted information can pass through a number of online devices to get to various servers and client machines around the world. This makes it virtually impossible to determine the location of messages. Because this is the case, it makes it difficult to know which nation's law on e-discovery should be applied or how they should be executed. Another note is e-discovery across national borders is typically expensive. Because there is a heightened level of complexity when it comes to requesting e-discovery through foreign channels, the cost of tracking information across borders is increasingly higher than e-discovery that is conducted solely in the United States. International laws regarding cybersecurity are versatile. This means that states around the globe have their own laws and regulations surrounding electronic data and discovery practices. Because of this, it takes time to appropriately take measures to contact the proper authorities before moving forward with an action. Just because discovery practices are legal in the United States does not mean they are in other states. Specifically, common and legal practices in the United States can even be considered criminal in other countries, so it is important to understand the rules and regulations of each independent state prior to attempting e-discovery within that specific nation. Foreign countries set the tone for their cultural boundaries. Because each state conducts its own rationale when it comes to ethics, there is difficulty in rationalizing the need for e-discovery to foreign countries. This is because each state will have its own view on privacy. In states where pre-trial discovery is not the norm, e-discovery is typically unwelcome and can often lead to misunderstandings and direct non-compliance. Because of these issues, it becomes vital for the United States and its representatives to explain American laws and customs prior to seeking international e-discovery. When dealing with acquiring evidence stored on foreign soil with consideration to cloud computing, various issues also arise. For one, it is nearly impossible to identify the target. When it comes to cloud computing, identifying the individual or entity responsible for an unlawful act is difficult because a client does not need to purchase software or hardware to use it. They just need to have internet access. In cases where individuals want to stay anonymous, they are able to do so without threat that they may be discovered. There also lies a jurisdiction issue. Even in the event that a target has been identified, different states follow their own jurisdiction and may decline an investigation if it threatens the sovereignty of their laws and regulations. There is also a lack of clarity when it comes to the legality of collection of evidence. Because there are no harmonious international laws set in place that dictate the collection of digital evidence, the process is typically questioned because individual nations may decline the authenticity or rationality of collection at their own accord to protect the reputation of their state. Now that we have spoken about challenges, it is important to consider that the United States is a member of various agreements that facilitate global cooperation when it comes to cybercrime. This enables the nation to conduct proper and investigative procedures that allow it to uncover the nation responsible for attacking the United States and its infrastructure. First, there is the Budapest Convention. This convention serves as the only legally binding international treaty on cybercrime. It defines common standards when it comes to investigations and facilitates cooperation in cybercrime cases for 65 member countries. This treaty provides an intersection for nations to create and blend their individual national legislation on cybercrime and fosters international cooperation. Next, we can talk about the UN Convention Against Transnational Organized Crime. This convention aims to prevent and combat transnational organized crime, and its provisions have been used to facilitate cooperation in cybercrime cases. Because 190 countries are parties to this convention, it is particularly helpful when delving into international digital evidence collection because it has a wide reach. Lastly, there is the Inter-American Convention on Mutual Legal Assistance of the Organization of American States. Though this convention is not specific to cybercrime, its provisions allow the United States to request from and provide legal assistance to other OAS nations, which help facilitate cooperation in cybercrime cases. During this investigation, decisions were made that considered the protection of the United States soil and its citizens. The United States government deployed a group of executive-level officials to forefront the investigative efforts. Each official was given specific areas of authority and worked with a large budget to protect the initiatives of the United States. The responsible team was able to successfully limit the hackers' full access to government systems that housed a damaging level of critical and sensitive information. When the ISIN revealed that there was a major cyber attack on a European bank, client notifications were immediately sent out notifying customers that an unauthorized user was able to gain access to the bank's servers that potentially exposed their sensitive information. After the initial attack was detected, increased authentication practices were set in place to minimize the chances for further unauthorized access. This included folder encryption to prevent further data from being compromised. Network administrators were able to implement a vulnerability management program that tested and applied patches to combat vulnerabilities so that hackers were unable to exploit them. Training procedures were also enhanced to ensure employees are aware of how to detect irregularities in computer systems. The recommended breach setting was set to critical, and in doing so, customer trust could be mitigated so that users could begin to develop confidence that their sensitive information would be safeguarded in the case of future attacks. This event proved that cyber attacks are constantly growing, and mitigation strategies do not just begin with having preventative measures in place when an attack occurs. Protecting a nation and its infrastructure also relies on having conducive and critical procedures to follow while an attack is occurring and after it has been experienced. The nature of cyber attacks are only growing, and physical borders cannot protect nations from experiencing an attack from outside actors. Because of this, it is just as important to execute conversations that prioritize multilateral international agreements so that nations are better able to depend on information sharing and helping hands to defend their countries from future cyber attacks.